Assalamualaikum warahmatullahi wabarakatuh, and I hope Madam is in good health today. And today we would like to present about Lloyds Bank versus BUNDY 1975. My name is Farah Ainaa Binti Mohamad Ali, and student number is 2018692612. And I would like to talk about the issue of the case. The case is about BUNDY's sons that operated a business that did not do very well, and he asked his father to give him collateral for taking loans from Lloyds. The father signed the original collateral, and later on the son need more collateral, and the only way that BUNDY could provide it was by using the house as collateral. And 5 months later, the bank foreclosed on the son's asset, and as he was bankrupt, they seized the house, and BUNDY refused to leave the house, and the bank should to have evicted. So, the plaintiff is the Lloyds Bank, and the defendant is Mr. BUNDY. Then we move to the next presenter.
For the next presenter is by me, Iman Anisa Binti Alwi, student number 2018295656. I will represent to you about what court held about this case. So basically, this is what held court about this case. Okay, Lord Denning MR held that the contract was voidable owing to the unequal bargaining position in which Mr. Bundy has found himself vis-a-vis the bank. He held the undue influence was a category of a wider class where the balance of power between the parties was such as to merit the interference of the court. It was apparent that Mr. Bundy had, without independent advice, entered the contract, and it was very unfair, and pressure were brought to bear by the bank. So, to be easily understand about what court held about this case, actually, this case was voidable because bank just advised Mr. Bundy to make the house as a collateral, and then Mr. Bundy just signed the guarantee without any force by the bank. So, basically, Mr. Bundy trusts a LLYODS bank to become his trustee, and a fiduciary duty is based on a trust. Okay, next will be represented by Afina.
I am the last presenter. My name is Afina Dayini Binti Mazlan. My student number is 2018256422. This case is related with the types of bank, which is the third type, trustee and beneficiary relationship. Bank may become a constructive trustee when this trust duty exists. It requires good faith for the relationship to exist. This relationship is independent of the contractual relationship between the customer and bank. The customer may not have an account with the bank. In this case also, bank has duty to advise his customer before the customer sign the guarantee, and information that given to customer must be full and fair. The relationship between the bank and the father was one of trust and confidence. The bank knew that the father relied on it implicitly to advise him about the transaction. The father trusts the bank. This gave the bank much influence on the father. Yet the bank failed in the trust. It allowed the father to charge the house to his ruin.